From wealthstack.ca, welcome to the Financial Wellness podcast series, where we discuss all kinds of financial principles, concepts, and products. Our aim is to make money matters simple again. Hey there. We have such a great opportunity to script and plan our legacy before passing away. Yet many people don't take the time to sit down and plan. As all of us know, when a loved one passes away, there are so many emotions and sorrow. One of the best things they could do for us is to give us clear instructions what needs to happen after their passing. In today's podcast, we are going to explore the basic concepts of wills and power of attorneys. At the end of the podcast, we will also share some complicated situations with you when it comes to wills. In my remote studio, I have Adam Cappelli, founding partner of Cambridge law firm in Toronto. Adam is a certified specialist in estate and trust law. Hi, Adam.
Good morning, Vincent.
How are you doing?
I'm doing well, thank you. How about yourself?
It's great to have you on the show. Adam, why don't you briefly just introduce yourself to the listeners?
Sure. I have been practicing law for 27 years, and the very first day I recognized a need in the estate and trust world, and so right from day one I've been practicing in estates and trusts, and which, in the most basic level includes estate planning and estate administration and estate litigation. And I've built a team of 10 lawyers as it stands today, practicing predominantly in the area of estate and trusts.
Great. So let me start the fireside chat today with a quick story. I'm fortunate to have my parents still alive, and over the decades, my parents frequently came to my brothers and I and explained their updated will, which is really fortunate. And so in earlier years, I didn't really appreciate this work that they've done for us. But in my last few years, I really see the benefit of that. A couple of things, and that is, it gives us so much peace and security as brothers to know that they've looked after their affairs, it's in order. If they pass away, we know that there's not going to be any strife between us. We've also seen that, for example, my mother have split up all the jewelry equally between their grandchildren, and they know what they will inherit from Oma one day. And so I have a very good view about wills and power of attorneys, and it's not a scary thing for us as a family. It's something that we openly talk about. But I can see that, many people just don't feel comfortable in terms of speaking about wills and power of attorneys and last wishes and these kind of things. And so, Adam, what I've seen on the stats is that about, 55% of Canadians don't have a will. And when people complete their dashboards on wealthstack.ca, and we also ask the question whether they have a will and power of attorneys, it's between 40 and 50% of the people don't have a will. What is that?
Vincent, that is human nature at its finest. The postponing to another day is an easy habit to get into. Procrastination, as we like to call it. I believe that's the number one reason for that high stat. And when you think about it, let's face it, planning one's mortality is a very, very difficult thing to face and do. So, if you're going to procrastinate something, it's, going to the dentist and doing estate planning.
So, Adam, in terms of a will, what are the main, so let's just dive straight into it. Let's talk about a will. Firstly, what are the main elements that goes into that will, and what happens practically if I and or my spouse, if we pass away and we don't have a Canadian will?
Well, you can rest a little easier, because if you don't make a will yourself, don't worry, the province of Ontario has scribed one for you. I'm being cynical, but in reality, that's the truth. There's legislation that doesn't just leave wealth into the proverbial black hole. There is a means to get it into the hands of your lineal descendants, which would include, if you're married, a spouse and natural-born children, whether with that spouse or not. It's just there's an immediate tax consequence, as you know, if you have a spouse and you die and you have a will that passes everything to your spouse, there's a tax deferral associated with that, and that's very attractive. Rather than, one of our tenets of wealth creation, as I've heard you talk about many times, is to defer tax as far down the road as you can. Mm-hmm. So there's a tax consequence. There is a real crisis that's created. Accounts are not accessible, benefits are not payable, parties, legal account holders and plan holders and administrators can't just say, yeah, I know, you're the spouse of the deceased and we feel terrible for you and we'll release the money to you. Legally, they cannot do that. There are creditor issues, there are contractual issues, there's the tax authorities. There are parties that have a claim on the estate and it will be frozen, and there's a legal proceeding that you must commence to get an administrator appointed. So I could go on and on and on and terrify our viewers. I think it's pretty widely known that there's certain things in life that you mustn't do and that you must do. Making a will is one of those must-dos. Not drinking alcohol in excess is one of the ones that you should follow, and this is right up there.
What are the most common power of attorneys that we need, and what happens if we don't have them?
Oh, okay. The powers of attorney go hand in hand with a will. People often think, they're going to die, and they don't think that they're going to suffer an illness or a disease or a catastrophic health situation that renders them incapable. They're still alive, but they're unable to make financial decisions or healthcare decisions. So certainly, powers of attorney, are I would say, I don't know the statistics exactly, but I would think that 85% of powers of attorney are activated at one point or another. If you're one of those people that's fortunate enough to live to the ripe old age of 95 and then drop dead suddenly, you've never activated your power of attorney. You've never had to suffer through a period of incapacity where you're a dependent, and we all think about that, and we don't want that in our lives. But, powers of attorney are quite often activated. I'm sure a lot of our listeners are seeing themselves thrust into that position for an aging parent. So you definitely need to have those in place, because if you don't, again, there has to be a court proceeding initiated, no different than if you die without a will. And getting a person appointed is not that easy, especially when there are family members that want to step up and they can't agree on who's to step up. So there's a lot of conflict created.
What is the difference between a living will and a power of attorney for property?
Okay, so a living will is the term that is really derived from American jurisprudence. It's a term that is associated with a healthcare power of attorney, except your healthcare power of attorney nominates someone to make your healthcare decisions. The living will is the portion of the healthcare power of attorney that describes to that decision maker the types of decisions you would want in certain scenarios. So, for example, in your living will, you might set out, I don't want to receive coronary or a feeding tube, or I don't want to be resuscitated with chest compressions. I do not want to be put on a ventilator if I have an incurable injury or disease. So you can get very specific and precise about your healthcare wishes. And so much so that the demand is so great that we have in my firm a full-time healthcare consultant who is somebody with over 30 years experience drafting policy and mediating disputes in the hospital setting in palliative care situations. So a lot of clients are reaching back and saying, we want to set up a detailed plan in the healthcare realm.
And then on the power of attorney for property, that's physically to bank accounts, anything to do with assets in terms of, to have someone to give authority in terms of how to release funds or selling property while you're still alive. Am I right?
That's right. So while you're still alive and you cannot make financial decisions, and there's a legal test to make that determination, but assuming a person's in a coma in a hospital bed, they're obviously not able to make decisions. Power of attorney for financial decision making is activated, and not only giving advice giving instruction to someone like yourself about how to structure investments, but there's also communicating with government agencies, starting a lawsuit if the reason for the incapacity is a result of an accident where someone was negligent. So you need a power of attorney to deal with all those property decisions. It's not just asset management. It's really anything to do with other than healthcare.
Adam, maybe just quickly on these two power of attorneys, is it then fair to say that your spouse is maybe the first person to be that power of attorney, and then another family member if they're not there? How many rolling people do you normally put into a power of attorney?
Well, we always recommend that you have an alternate. So you name a primary decision maker. That's usually a spouse, or if you're not married or in a relationship, it could be a common law partner. But if you're not in a relationship, a lot of people default to their children, and a lot of people, mistakenly, assume that blood makes a good fiduciary or decision maker, and it's oftentimes doesn't work out to be the best choice. So you can think about a trusted advisor, a lawyer, an accountant, financial advisor, and if you're not even comfortable, you can go to a corporate trustee. There are trust companies in business to serve this need for those that don't have a suitable family member or financial or trusted advisor.
Thanks, Adam. Let's just jump back to the creation of the wills, and especially with parents with minor children. Mm-hmm. That's always a complication. Also, if in Canada, a lot of people immigrate here. They have obviously some of those guardians are in their country of birth and may not be in Canada. Maybe just quickly talk to us around guardianship, and then also a will normally allude to a testamentary trust to be set up for minor children.
Yeah, earlier, and I don't think I actually got into the details or a detailed answer of your question of what is in a will. And the first thing that you're doing in a will is you're addressing all those arrangements that you might have designate a beneficiary. So, for example, someone might say, why do I need a will? I have everything in joint names, or I've designated my registered plans and my pension plans to my spouse. Well, obviously, if you died together, that's a problem. There's no contingent named. So the first thing in a will you want to address are all those plan designations that are out there where you've named a primary but not a contingent beneficiary. So you want to take care of your contingent beneficiary appointments. You want to nominate an executor. And that executor might be someone who carries the same responsibilities as trustee for your children. You want to make sure your children don't receive, $500,000 at the age of 18. So you want to set up a trust, as you pointed out, and you may want to consider who's the best trustee for that trust. It may not be the executor, it could be a separate person. And then you want to look at, okay, who would be the best person to guide and raise and be a great substitute parent, and those are the guardians. And you want to make sure you designate them in the will as well. If you have young children, children under the age of 16, it's not 18, need to have a guardian appointed. After 16, they're in the eyes of the law able to move out and live on their own and refrain from being under parental control. That's one of our greatest fears as a parent. You die, you leave your child at a very vulnerable age, and they have a difficult time with it, and they don't find a compatible guardian, and they end up on their own way too young trying to look after themselves.
And then just quickly, the question around guardians in different countries, is that a complication?
It is a complication because, as you can appreciate, it's not an easy administrative task to exit a country and end up in another country under guardianship. Like, in other words, you might, the Canadian government is not bound by foreign guardian appointments. So if you came to this country from another, let's say South Africa, for example, and you've nominated your guardians in your home country, your country of birth, when you die here and your children are here, the government authorities need somebody to immediately step in and look after your children, and then a court proceeding has to be commenced to officially appoint those guardians. So it's not insurmountable to have the children move back to South Africa, particularly if they have citizenship there. But if they don't have citizenship there, it becomes an immigration issue, and it's more complicated. So all the more reason why you need to have a will that puts in place a temporary guardian to look after your children until such time as those foreign residents can come here, get the paperwork through the courts so they can take the children home with them.
I think that's also for me and my family, coming to Canada. In the earlier years, it was definitely the case of that they will go back to South Africa, to the guardians over there. But now being here a few years, and making friends and, having family here, it's a lot easier and a lot better for them to stay here. And so that's maybe just another thing to always update within that. Adam, if we can just talk about the executorship. My question here is there a difference, or what is the complication of appointing an executor versus a professional executor? Can I appoint any executor and they have to go and sort it out, or is it better to appoint a professional executor?
That's a really good question, and it really depends on the client's circumstances. So a lot of clients, again, are penny wise, pound foolish, as the saying goes, where they don't want to pay for a professional, trustee or executor. And when you're paying for a professional, what are you getting? First of all, you're getting experience. That counts for a lot. Secondly, you're getting someone independent, somebody who's not conflicted. If your son has been borrowing money from you and is now your executor, often they get in conflict with their siblings because the siblings are wondering, well, why isn't interest being paid on those amounts, and were they not supposed to be repaid? And there's a whole host of reasons why your family members might be conflicted. Independence is very important, and that's why you would appoint a trust company. And as well, if they make mistakes, they can be sued. They have insurance, deep pockets, and it's a lot less awkward. If you can envision a situation where one son is the executor, one son is not, that son who's not is wondering what's going on with mom's estate. Why haven't I received any reporting? Why haven't I received my inheritance? And then they make that call to their brother, and the brother's, very sensitive about, about his one brother insinuating he's not doing a good job. And next thing you know, they're in conflict. So your legacy is, a conflicted family now. Sometimes independence can avoid that awkwardness and that dynamic. If you're telling a trust company, listen, I think my brother has borrowed money, you may want to make inquiries. They can make those inquiries as part of their due diligence without, fragmenting the relationship between the two brothers.
Adam, it sounds like there's a lot of not so good stories when it comes to implementing and executing these wills, and maybe not so much the power of attorneys, but maybe more the wills. And it kind of leads me back to the story of my parents. It just creates so much security and peace if the parents do their wills up front and they talk to their kids, as opposed to leave it, no one sees it, and then there's a surprise one day when the will is read, and maybe then the kids that were friendly become unfriendly.
There's so many practical steps that we don't have time for today, and maybe we'll have time on another session together. But locating the original will. Some parents are so secretive the children don't even know what lawyer they were dealing with. Now, hopefully, moving through their private papers, all that can be figured out. But we're now entering a paperless age, as you know. We're well into a paperless age, and sometimes piecing together what a person's financial footprint is a lot more difficult today.
So just to recap, a family, so let's say a nuclear family, husband, wife, kids, so they need each a will, so there are 2 wills, and then each parent will have their own 2 power of attorney, so that's 6 documents in total.
Mm-hmm.
What is just what you also mentioned just earlier in terms of saving the will, having a hard copy, soft copies, how does that run? Which one is the valid one? Are both valid? Where do they need to store it? What is the best practical steps there for people?
In most cases, the originals are left in safekeeping with the lawyer, and the reason for that is so that they're stored properly and they're not destroyed in a fire or stolen in a home robbery. So safekeeping is very important. And the other reason is, when clients have documents in hand, sometimes it will make handwritten alterations, and it has an unintended result where they revoke the document in error, or they amend it in a way that's ambiguous. So lawyers like to control the document so that when the client wants to make a change, they call, and a solid discussion occurs to make sure they don't inadvertently put matters into their own hands and create an error and a bigger problem. So document control is so important. Most institutions will not accept a photocopy. They want a certified lawyer copy anyway. And so if you're holding the original and you have to get certified copies, then you have to attend at the lawyer's office with that original. Whereas if the lawyer has the original, they can make the certified copies on the spot and in a quick way get them out to the family members.
Great. Adam, for those people that already have a will, what is the process going forward with them normally? How often, how frequently, when do they need to update that will and power of attorneys?
Well, the obvious milestones that should trigger an update are if your wealth increases substantially, you can look at, tax minimization strategies because you're a higher net worth individual. You can change your will plan because of that. If you separate, divorce, those are obvious reasons to amend your will. If a child is struggling, with mental health or substance abuse issues, then you want to look at, should they have a trust moving forward? That's a good time to amend your will. If your children are old enough to be your executor and you have one of your best friends named, and they're getting older and they may not be around and willing to do it, that's an obvious trigger. If you acquire assets in foreign jurisdictions, do you want to update your will? Guardians that you once were in very close contact with that you're not so close with, or you're not impressed with some of the decisions they've made with their own children and you don't want them raising yours. Those are other reasons to update your will. And so you've acquired life insurance, more life insurance, you should update your will. Those are the obvious triggers.
That is great. Maybe just the last last point from my side, and it's a softer point, and maybe also just speaks into this thing of this decision making and being more comfortable in terms of talking about these difficult things about passing and mortality is actually something that I've done a few years now, is to write letters to my kids, but I don't give it to them. I write, I want to say, a yearly letter to my 3 kids, and I just keep it in safekeeping. It's part of the world that they will see one day, and maybe it's a good memory of a letter that I've wrote to them. But it just helps me, I think, just to kind of think about mortality and think about what I want to leave them. Yes, there's legacy in terms of finances, but then there's also legacy in terms of who Karen and I are, and what we want to leave them with that last final thought kind of thing.
That is, I'm so happy you mentioned that. I've done the same. My worst fear, and I think you're telling me your worst fear, is passing suddenly without having those last words of goodbye. And I have letters drafted to my wife and to each of my daughters, and they're messages that you would want to most definitely, you would want to resonate with them and take them forward. And well, a lot of our listeners should say, well, the two of you should just be better communicators while you're alive. You should be telling them these things every day, and I'm sure we do. But to have it scribed and there and physically written is a lot more meaningful. But you've hit a real good point, and that is, it's not just about the legalese, written will. You need to have these letters of wishes. I have gone so far as to specify the final arrangements and the music. That I'm a music lover, and the people that would be invited, because you're putting your family in a period of crisis where my wife would not know which who to notify and who to invite to a celebration of life party, that type of thing. So I'm so happy you mentioned that, Vincent. That's so much an integral part of your legacy. I can't believe how people will spend hours and hours and hours planning events that are so much less significant.
Maybe just the last thing on the letters, and that's it. I don't write neatly, so my kids can read into my handwriting whatever they want to read into it one day. So.
Well, that's why there's a podcast. You could do electronic file. You just need to know where to find it.
That's right. Adam, thank you so much. I know that we can talk about this thing for hours and days, just because we like to talk about legacy and help people to move forward in life and to plan well. But I want to thank you so much for your time. I know that you also have a webinar once a week, and maybe just give us a view on that and where people can find it.
Sure. Thanks for bringing it up. Every Wednesday, between 4 p.m. and 4:30, 30 minutes, we at Cambridge LLP get on a live webcast and talk about estate planning issues and estate litigation issues. So we're fairly new at this. We are now, I think, entering episode 6, so you're not too late. We've been on air for 5 weeks, 6 weeks coming up. And this next one, we'll talk about common law versus married. Are they the same thing? And we have our senior litigation counsel, Dr. Douglas Elliott, who's being interviewed by Tim Phelan, who's an estate litigation lawyer on my team. And I'm sure a lot of our listeners would be enlightened by that discussion.
Thanks, Adam. Yeah, there's so many things that we can talk about: disability in a family and foreign assets, and as you say, different power of attorneys and family trust. So there are plenty of stuff. And listen, thank you so much for your time. Really
My pleasure.
appreciate
Thanks.
it.
Thanks for having me.
And I'm sure we're gonna talk again. Hey, thank you so much for listening to our podcast today. You can find our content on wealthstack.ca or on LinkedIn. I'm Vincent Hayes, and you've been listening to the Financial Wellness Podcast Series.